But we do have a breaking story for us, and it's taking place in Pretoria. Parole being denied to Oscar Pistorius. Singabakho Nxumalo from the Correctional Services Department has just begun a short while ago addressing the media.
Inmate Oscar Pistorius and the victims of the crime, they deliberated and they've arrived at a particular decision which was largely guided by a clarification order from the Supreme Court, which stated that Mr. Pistorius has not yet reached the minimum detention period. And when the parole board went through that, they then gave him what we call a further profile for August 2024, meaning that he will have to appear again next year, and they will then look into the profile and make a decision in terms of his placement. But for now, it was a matter of saying he has not served the minimum detention period. In simple English, half of the sentence is yet to be served.
So who made a mess of this? Because you told us just earlier today that he had served enough time.
The clarification order from the Supreme Court of Appeal, we can share it with colleagues, it's not a secret document. It was only received on the 28th of March, meaning 2 days ago. And it was also provided to us when the board made its particular decision.
So when will he actually become eligible?
In August 2024. That's what we call further profiling, meaning that, as explained, no one is said to be denied parole. But if there are interventions, you provide space for such. But if a person is yet to serve the minimum period, you also provide for such. Hence, it is called further profiling, meaning that come August 2024, he would have reached the minimum detention period. Then the board will make a decision.
What does this mean for Oscar Pistorius? Does he remain here at the Atteridgeville Correctional Centre, or will he be taken back to the other facility at Kgoshi-Mampuru? In terms of what I'm trying to understand is the profile of him now.
Yes. What it means is that Mr. Pistorius will continue serving the sentence, and as we have inmates with us all the time, continuously we assess the risk and make a decision which is in the best interest of the inmate. If there is a need that he be transferred to another facility, they will do so. If he's to be kept here, that will also happen. But for now, he continues to serve a sentence.
This had nothing to do with his behaviour. It's got to do with the fact that he hasn't served his minimum sentence.
Yeah. The Correctional Services Act is very clear that an inmate has to serve a minimum detention period before he is considered for parole placement. So it is something that you cannot subvert and replace it with something else. You have to serve that minimum detention period. Then thereafter, your suitability is being considered.
If you knew 2 days ago that he was not eligible for parole due to the timeline, why did we have this proceedings today?
I think your question does answer itself. If when you, as I've said, we received that note today to say this is what was received from the Supreme Court of Appeal, and again, it's a parole board that makes it. It's not us as Correctional Services. Our work is to rehabilitate an inmate and present an inmate before the parole board for their consideration.
A few more details about that decision. In other words, where the calculation got wrong, and why it is that he has to serve an extra year.
What has been happening with this particular case, it has not been an easy one. I think we've had about 2 or 3 clarification orders, if one is not mistaken. So, and hence, when you read the final one, it does say that it's I think the technical language is like it's the final one. It's not substituted by any other order. But as I've said, it's a document that you can willingly share with the media.
Mr. Nxumalo, I just want to understand, so this clarification from the SCA was provided on the 28th of March this year, so
which
just
is 2 days ago. Yes.
That was before you insisted or stated on record that Pistorius did in fact qualify for applying for medical parole.
Yes, because we used the previous record that was in our possession.
Yes.
And we've stated that we've had, I think, about 2 orders before this one, giving us the minimum day period. So if we have this one, it says final, we have to take this one.
Thank you.
We cannot reinterpret it the other way. We just have to take what the court tells us. But even with this particular case, it is not Correctional Services that makes a decision. The parole board will do that.
That's very clear. What I'm asking you is, who sought the clarification obtained on the 28th, and to whom was it sent? Because it's clear it wasn't sent to You or your seniors? Was it sent directly to the parole board, and who requested it?
I think our processes, can make that determination, but I think what is done here has to be in the best interest of justice.
Yeah,
so in terms of, say, who made that particular request, who received it, I think it's something that we can deal with some other time. But for now,
I think it's very important that we deal with it now, because we need to know who asked for it. It was provided by the SCA on the 28th.
And we are committing to say, once we have everything before us, that we can make it available. But what is important is that there is an order that has to be respected.
Of course.
I think
when
that
can you commit
is
to providing
cardinal.
that clarification to us? Surely it's just a matter of making a call or sending
surely
an
this
email.
matter will continue to receive interest. So I think even us as a department, we owe it to the public there to give far more details if there is any
So
more to
I'm
be said
asking
after
you if
this.
you could please provide clarity on who asked for that clarification from the SCA and to whom it was sent, ideally by close of business today.
I don't know whether I need to repeat myself. I think I've answered that question.
Do you know if the news has been communicated to Mr. Pistorius?
Okay, how the process works is that once the board has made its decision, the priority people are the victims and the inmate. Then they will be informed as well as a department. Hence, a bit of a delay when I think the decision was made, I think, to some of the lawyers, and it took us a bit of time as a department to confirm that, because we needed to get it from the parole board to say this is a decision that we've taken and we've communicated with relevant parties. It's only after that as the department we can go out and say what was the decision spot.
Okay, so I just want clarity. This has only got to do with the fact that Oscar Pistorius has not served his minimum detention term. It's got nothing to do with behavior or any other factors that are used and considered for parole. It's only got to do with his term.
The note that we have before us only cites the issue of the minimum detention period. If there are other details, those could be available to us, but the note that was given to us at this particular time was that the minimum detention period has not been served.
Do you feel like there's any egg on your face as the Department of Correctional Services, in the sense that the communication that had been out there all along was that Oscar Pistorius was eligible for parole, and then now what we're hearing is that communication somewhat received on the 28th, which
saying
is just,
something different.
Yes,
Okay.
So do you feel like you've got egg on your face? Because, I mean, this process then should not have gone ahead had the communication been received on time, and these proceedings and, I guess, putting the Steenkamps through this kind of pain, which they described to the media a bit earlier on today, should not have happened to begin with.
As I've said, we've had a number of orders, and you have to work in line with what is before you. And when you get a supplementary order, an updated one, you cannot ignore and say, because this is what you've said based on the previous one, therefore we're not moving. You have to respect decisions of the court.
So is it failure then to communicate timelessly to avoid all of this then? Because somewhat, this information you say you received on the 28th...
And was only made available to us today.
Only made... So
yes.
Somewhere along the line, the communication certainly could have arrived earlier to avoid... the victim's family and Mr. Nxumalo from going through this kind of pain.
I think it's something that one can always just say, when was it issued and when was it delivered to us? I think technically, and I wouldn't want to go around circles around that, because what matters is that we've got that clarification order, and the parole board has made its decision based on it, but there could be other material issues which are not in front of me as yet. All that we're communicating for now is a decision of the parole board. And if there is any other material that could be provided at a later stage, that can be done. And we've affirmed that that order by, the clarification order by the Supreme Court of Appeal, we can make it available because it is not a secret document.
But it is unfortunate, though, that this communication only arrives on the 28th, and you're saying you only received it this morning. It is unfortunate because, I mean, the victim's family, at the end of the day, the victim's family have long been saying they wanted a process that was, victim-centric. So in an instance like this, the family has once again, even though they didn't face Oscar Pistorius...
If you can allow me, we have received the order, and that was made to the parole board. It has made this decision, and that's what we are communicating.
Mr.
Thank you.
Just lastly,
I hope this is the last question, because we are only communicating a decision of the parole board.
I understand that. Thank you. Last question here. It's been a rough week for your department.
Yes.
This is obviously a very high-profile matter. You've been mindful to emphasize that there's no special treatment, etc. If something like this has happened, and 3-4 days after the fact of an SCA decision on a significant development in terms of an accused parole eligibility is not before you. You have no idea about it. What hope do other inmates have when it comes to the handling of their parole board applications?
Okay. It is not normal that we receive so many orders, supplementary orders in a particular case. In my history with DCS, I've never seen something like this. And I guess I think it's something that can even assist moving forward to say, how do we handle such matters? When do you go to court to seek clarity and all those things? But that is a subject for another day. I think for now, let us communicate the decision of the parole board that it is a further profile for August 2024, and we've committed to say if there is any other material which will be of use to the public out there, we can share such details. But for now, that's what the board decided. It's an independent structure. We cannot act against their decision. But those affected, there are remedies available to them should they wish to take the matter forward.
Thank you.
Thank
you
you,
can
ladies and
provide those
gentlemen.
details we asked for as well.
Thank you.
Okay, thank you so much.
All right.
That is Singnabako Khumalo, who is the spokesperson for Correctional Services, and I think just really giving us a clarification on what exactly happened here. And of course, it's important to highlight that the reason provided, so we do understand that Oscar Pistorius has not been granted parole, and the main reason provided is that the inmate did not complete the minimum detention period as ruled by the Supreme Court of Appeal, as per clarification provided on the 28th of March. It's the 31st of March today. That clarification, of course, being handed down on the 28th of March, but according to Correctional Services, that was only given to them and upon their knowledge this morning. So there's a lot of questions around why this was only given to them this morning, why the Steenkamps had to actually go through this whole process of providing a victim impact report, and even Oscar Pistorius himself having to make representations before the parole board when he wasn't even eligible because he has not served his minimum detention term. We had all been under the impression that he had served over 8 years out of the 13.5 years that he had been sentenced to, but it seems as though, according to the Supreme Court of Appeal clarification order, he has not served the minimum detention term. Therefore, he is not eligible for parole, and determination and consideration will only be made August 2024.
Very much, Heidi Jokos, for that latest update there from the Correctional Services Department.